Okay, Ms. Rivers, can you hear us?
Yes, I can. Good morning.
Good morning. We're going to get started. This is position 20. We're going to, sounds like, take a couple pleas this morning, positions 20 and 22. Position 20 is where we're starting. It's Ms. Vila. She is here in court with her lawyer, Mr. Melnick. Ms. Clark is the prosecutor. And we are, I think, set to move forward. Mr. Melnick, are you and your client ready?
We're ready, Judge.
Ms. Clark?
Yes, Your Honor.
Great. Ms. Vila, in just a moment, Ms. Clark's going to put you under oath. Once you are under oath, make sure you answer her questions and mine truthfully and completely. And also make sure that you let Mr. Melnick or me know if you've got any of your questions, any questions of your own. It's important that I am comfortable that you understand what's going on. It's not meant to be a complicated proceeding, but it's stressful, and someone may say something that doesn't fit with what you and Mr. Melnick had been discussing, and I need you to flag that so you're comfortable at the end. You've understood everything we did, okay?
Yes, sir.
All right, Ms. Clark, when you're ready.
Yes, Your Honor. For the record, I wanted to state, Your Honor, that the state, the defendant was originally charged under kidnapping OCGA 16540, but the state will be recommending a downward departure to the crime of false imprisonment under OCGA 16541.
All right.
And defendant Vila, is it Vila or Villa?
Villa.
Villa, okay.
Thank you. Please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down.
Okay.
Please state your true, correct, and legal name.
Morgan Nicole Villa.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
31.
How far have you gone in school?
I have my GED.
Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offense? 1 count of kidnapping under 16540, but the state will be recommending the charge be changed to false imprisonment under 16541.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had time to review your waiver of rights with your attorney?
Yes, ma'am.
And did you understand your waiver of rights as explained to you by your attorney?
Yes, ma'am.
And is it your decision to waive your rights today?
Yes, ma'am.
And did you have an opportunity to review the indictment with your attorney?
Yes, ma'am.
Okay. And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to this charge?
Yes, ma'am.
Would you like more time to discuss the case with your lawyer, attorney John Melnick?
No, no, ma'am.
Are you satisfied with your attorney's services?
Yes.
Attorney Melnick, do you waive a formal reading of the indictment for purposes of this plea?
We do, yes.
Do you waive any and all defects in the indictment for purposes of this plea?
Yes, we do.
Your Honor, the state is unaware of any outstanding warrants related to this charge. Do you remember having been arrested on this charge?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for the charge of false imprisonment to which you're pleading guilty today?
Yes, ma'am.
Okay. I'll provide that for the record. The minimum is 1 year. The max is 10 years.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state will recommend false imprisonment, a sentence recommendation of 7 years probation with special conditions as set forth below. A behavioral incentive date after 4 years if no further violations of the law. The special conditions are a drug and alcohol evaluation and also a mental health evaluation and treatment within 30 days. Mental health evaluation within 30 days and treatment on either one of those if recommended or required. No contact with the victim, Abigail Brenmuller. Her name is spelled, and I know I'm messing that up, Brenller. A HIPAA waiver to monitor mental health treatment if deemed necessary. No drugs unless prescribed, and no alcohol.
Yes, ma'am.
Is that your understanding of the terms?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Are you currently on probation or parole?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you face a sentence between 1 and 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
You understand that if you were in the future to use a firearm in the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm just going to read a lot of rights and then just ask you a question at the end. You're giving up the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charge of false imprisonment in indictment number 23 SC 186934?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge
Yes, ma'am.
against you? Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file a habeas corpus petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the plea in this case. If this matter had went to trial, Your Honor, the state would have been able to prove beyond a reasonable doubt that on November 2nd of 2020, at the incident location of 920 Spring Street in Fulton County here in Atlanta, Georgia, while out on an unrelated traffic accident, Hage, H-A-G-E, was flagged down. The victim, who is Abigail Brunell, at the intersection of William Street and 10th Street, Atlanta, Georgia, 30309, in front of the Hilton Hotel. The victim advised she was driving her 2017 black Subaru Forester South on Spring Street when she approached the pedestrian red traffic light at the intersection of Spring Street and First Peach Street Place and stopped her vehicle. She stated that when the traffic light turned green, a white female suspect walked in front of her vehicle. The victim then stated that she waved her hands at the suspect to move out of the way of her vehicle. She stated the suspect, later identified as a defendant in this case, approached the passenger side of her vehicle and forcefully entered and told her to take her to the Wells Fargo or we're going to have issues. The victim stated the suspect then reached into her bag as if she had a weapon. The victim was unsure if the defendant drove south, had a weapon, and so she complied and drove south on Spring Street to the intersection of Linden Street, where she turned right onto the entry of I-75 and 85 northbound expressway. After she merged onto the expressway, she stopped behind an unknown vehicle due to traffic. She then took her keys out of the ignition, exited her vehicle, and began yelling for help. Shortly after exiting her vehicle, the defendant exited her vehicle and entered another unknown vehicle. Your Honor, the state has been in communication with the victim in this case, and the victim is aware of the fact that the state is recommending a downward departure to false imprisonment, and the victim is fine with that. She is of the opinion that based on her observations and her experience with the defendant, that there is maybe a mental or drug issue going on, and she does not want her to do prison time.
Okay, so it doesn't sound like Ms. Brenler had anything taken. Must have been very frightening and disturbing, but in the end, she was able to drive away with her black Subaru intact.
That is correct, Your Honor. And in fact, the victim did provide officers at the time of reporting of the incident that the defendant did leave her purse in her vehicle.
Okay, got it. All right, thank you. Good morning, pretrial. Can you share with me, please, what criminal history information you have on Ms. Villa?
This defendant has 20 arrest cycles in Georgia, felony conviction in 2011 for theft by taking, where they received first offender treatment. It was sealed in 2015. 2016, criminal damage to property and theft by taking. 2022, aggravated assault and hijacking a motor vehicle. 3 failure to appears and 3 probation violations. Nothing further to report.
What's the most recent arrest that you've got?
One moment.
We're okay if those don't connect today. We're a small group, so appreciate you coming by. We're all right. But we may want to figure out on a long-term basis what's going on.
Okay, the most recent arrest was in September of 2022 for a probation violation out of Carroll County.
Okay, last question, and thank you for all this. The 2022 conviction for aggravated assault and carjacking, what was the jurisdiction for that?
DeKalb.
DeKalb. All right. Thank you, ma'am.
Mhm.
Good morning, Ms. Tucson. How are you?
Morning, how's everybody?
Everybody's good. Tell me, please, if Ms. Villa is on, she seems to think she's on probation right now. Is that Fulton probation or other jurisdictions?
She is on probation in Carroll County and she is on probation in DeKalb County.
Okay. All right. And what's the sentence she got for this aggravated assault carjacking, if your system can tell you?
That was in 2022.
Yeah.
I'm checking motor vehicle. Let me see. It says as to count 1, 10 years to serve 5 years in custody, custodial time suspended.
Okay.
And it says, and then concurrent to count 1.
Okay.
And
All
it just says special conditions, defendants to comply with any recommended mental health treatment and pay restitution if ordered.
Got it. All right. Thank you. Mr. Melnick,
Thank you, Judge. So
tell me what's going on with Ms. Villa.
Shed some light on all of
Yeah.
this. I represented her in DeKalb County. I also represented her at her probation revocation hearing in Carroll County. And so Ms. Villa has a long history of mental health issues that have been exacerbated at times by drug use. So she did a pretty fair amount of jail time on that DeKalb County case. It was close to 2, was it
2 years.
2 full years on the DeKalb County case. What they agreed to, and what we were able to demonstrate that there were mental health issues. That incident occurred on the same day as this incident.
Okay, just across county
That's
lines.
correct. That's right.
15 minutes.
And part of her sentence in that case was to enter into and complete the Mary Hall Freedom House, which she has done. And any aftercare that has been recommended, she's in full compliance with all of that. We completed that case, I think, over a year ago, if my memory is correct. And she's actually been doing very well. She's been in compliance with all of her mental health treatment. Was it right before this that your daughter was born?
Yeah, right before it, 2 months.
So yeah, her daughter was born 2 months before she was arrested on these two. Well, she didn't actually get arrested on this offense until after she got released from DeKalb County. So she was brought from DeKalb County over here, and then we were able to get her a bond. So
When you say after, meaning after she did the almost 2 years?
that's correct.
And that almost 2 years was in the DeKalb County Jail, not plea, go to DOC. It took a long time for that case to sort itself out. When it was sorted out, it was this sentence of 10 serve 5
Yes.
Custodial term suspended.
Suspended upon the condition she complete whatever mental health.
Mary Hall, Freedom House, et cetera. Okay. And it was only then when you got that sentence for her and Ms. Villa was released that she came across to Fulton, and then you got her a bond on this case.
I did.
Okay.
Yep. So anyway, her daughter has unfortunately very significant issues as well. That's why I had let the prosecutor know that full-time employment is a little bit difficult. Ms. Vila is married, and her husband has a construction business. Her daughter is severely autistic. She is treated at is it the Marcus Center? Am I right about that?
No, the Georgia Autism. She has in-house therapy Monday through Saturday, 8 hours a day.
So she has a lot, Ms. Vila has a lot on her plate right now. Even with that, I can tell you, Judge, the difference between her now and when I first got into all this is absolutely night and day. She's doing really well. I think that the treatment did her a lot of good. She has obviously struggled with this issue her entire life. I don't remember off the top of my head exactly what her diagnoses are. I'm sure she can tell you. But like I said, she seems to be doing very well. This incident was really just a complete breakdown, probably resulting from some form of postpartum depression, combined with all of her other mental health issues.
Okay. Ms. Villa, so you are married now. Were you married back then?
Yes, sir. And I had just had my child with him. Everything was going good, but I wasn't on any type of mental health medicine. So when I had my baby, I started feeling really weird, and I think it triggered my actual mental health that I've had my whole life. I just haven't ever tended to it.
What kind of medication are you taking now to tend to it?
So it's it's called Geodon, and it's for bipolar and schizophrenic. And it's so great. It helps with my thoughts. I don't have any weird thoughts or crazy thoughts that people are doing there. It's just so much better. And I take medicine, hydroxyzine for my anxiety. I take Seroquel for also my schizophrenia /bipolar. It can be treated for both of them. And I'm actually on, it's called opiate submission. So I'm in treatment for my addiction as well.
Okay. When you say you're in treatment, you're getting counseling for it, or you're taking a medication?
So I take medication. It's like buprenorphine. And then I go to AA meetings. Most of them are online. I do get in-person meetings, but with my daughter going through 8 hours therapy a day, I'm heading back to the house and her therapist is going to meet us there. It's a lot, but I can do it. And I wouldn't be able to do it without my mental health medication. So I know I have to take care of that before anything. I always eat as soon as I get up and take my medicine.
Okay. And your medicine is all morning medicine?
Morning. And I take my anxiety throughout the day. I can take it as needed because my anxiety seems to peak sometimes. And I've just learned to watch myself and observe myself.
Okay. And your husband, works in construction or has his
He
own
has his own
construction?
construction business.
Okay.
Yes, sir.
And that income is enough to support the three of you such that you don't need to work right now?
No, I do not, sir. We also have two other children,
Okay. Are they older than?
13 and 8 years old.
So they're in school?
Yeah, they're in school. They're great.
Okay. And are they pretty healthy?
Yeah, awesome. Yeah.
Okay. And are they children that you have with this gentleman?
No, they're my stepchildren, but they
Okay.
live with us
Got it. And where is it that you live? What county?
in Austell, Cobb County.
Cobb County? Okay. All right. Do you have any questions about anything we've discussed?
No, I just want to apologize for the incident. It was really crazy, and I know it was traumatic as well as for me, but more for her, I'm sure. And I just apologize.
Okay. Well, thank you for doing that. I'm sure the district attorney's office will convey that. And you're fortunate that it sounds like Ms. Brendler basically wants you to be well, and that she also was able to ascertain that this was an episode, and that you weren't well, as opposed to you were violent and evil and
Yeah,
anything like
thank
that.
God.
So, and I guess we're all fortunate that she didn't have a gun in her purse, because it could have ended real differently for the
Yes.
person sitting in the passenger seat. All right. Well, Ms. Villa, I find there is a factual basis for your plea, and that your plea is knowing and voluntary, so I will accept it. I am sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, for this case at least, if you have a technical violation, maybe you miss a meeting or something like that, you and probation will work that out. You don't have to come back and see me so I can say, go to your meetings. But if you have a more meaningful violation, you get arrested again for anything, that comes back to me, and we'll work through the consequences of that arrest. Mr. Melnick, we signed the indictment on your behalf indicating the guilty plea?
Yes, sir.
And Ms. Clark?
Yes, sir.
And Ms. Villa, is it okay if we put your electronic signature on the
Yes, sir.
indictment? Great. All right. Your charge has been reduced by the prosecutor to false imprisonment from kidnapping. I will follow the negotiations and sentence you to 7 years probation. I will set a behavioral incentive date of October 4, 2027. So that's 4 years from now. If all is well and you've kept probation happy and stayed out of trouble, they can close the case out then. That'll be a way to get out from underneath this probation early. I don't know how much probation you have in DeKalb or Carroll. It may be mountains. You got to deal with one case at a time.
Right.
Of course, all your probation will be running concurrently. It's not one after the other, and they're all supervised out of one place. So if you live in Austell, then your probation officer will be out of Cobb County, if that's where Austell is.
Yeah.
Okay. I'm going to recommend that the Department of Community Supervision assign a mental health probation officer to work with you. I don't control that, but they have officers who are particularly attuned to supervisees who need to be taking medication, and they can work with you to ensure you're doing all the things you need to do, and just be looking for signs that, that behavior was a little different. Are you still on your medication? Special condition of your probation number 1 is no contact with Ms. Brendler. I know she's a stranger to you, but don't look her up to say, hey, I'm sorry about what happened. She needs to be able to go in her direction, and any contact would come through the DA's office and not through you. I'm not going to require you to have a mental health evaluation. It was a solid recommendation, but now that we've heard from Mr. Melnick, you're getting treatment. And so what I am going to require, this will be a special condition of your probation, is that you continue to take all prescribed medications. You don't decide when you stop. A doctor does. If the doctor says we're going to scale back the buprenorphine because it's seeming stable on the opiate side, great. But the doctor decides that, and not Dr. Villa.
Okay.
You keep taking whatever they tell you. Now, if it's creating weird side effects, that's dialogue you have with the doctor. And if your doctor switches things up, great. But you take what the doctor switches to. If you're not taking your medications against doctor's orders, that's a violation of your probation. And that's something that we'll need to talk about. And that's meant to be protective and not patronizing. It's keeping you safe. It's keeping your kids safe. And it will also be a special condition of your probation that for at least the next 6 months, you continue your addiction counseling. I can't require it to be AA, but I can require you to get counseling. And so if that's going to group sessions through AA or NA, that's fine. You'll just need to show your probation officer, I'm going 2 times a month or 2 times a week, whatever frequency is working for you, other than 0. 0 times a month wouldn't be continuing the addiction counseling.
Yes, sir.
Ms. Clark, any other special conditions you want to see? Okay. Mr. Melnick, anything else?
No, Judge, that's all.
Okay. Ms. Tucson, tell me tell Ms. Villa what reporting instructions you have for her. It sounds like she's already plugged in with DCS.
I was just sending Mr. Melnick an email just to kind of touch base with all of her information. Are you still living in Austell, Ms. Villa?
Yes, ma'am. I actually spoke with my Cobb County probation. She said that she would just be looking for a transfer or something. That's what she told me last week.
And is your phone number 470-910-4401?
Yes, ma'am.
And you're on Wanda Lane?
Yes, ma'am.
Okay, then I will give you a call just to let you know when your case is, this new indictment gets uploaded to portal and sent over to your officer.
Thank you so much. So it's going to be a transfer, correct?
Yes, if you live there, you will be supervised there.
Thank you.
All right. I think that's it. Yep.
Thank you.
Good luck,
so
Ms.
much.
Villa.
Thank you.
Yes, ma'am. Thank you. We'll see you. I don't think this week we've got more criminal because we were supposed to be in trial and dang. So we'll see you whenever next.
Yes, Your Honor. Look forward to it. Thank you.
Same. All right, Mr. Washington, if you'd come on up, please, and sit with Mr. Melnick.
Ms. Clark, my victim witness advocate is present on Zoom to read the victim impact statement.
It's a little confusing. So we've got a Clark here and a Clark there, and they're both sort of derivations of Chris something.
Yes.
Yeah, I'll keep them separate.
Kristen Clark.
Yep. All right, give me 1 second and we'll get started. Okay, let's pivot to position 22 on the trial calendar. It is State versus Adrian Washington, 23 SC 186964. Mr. Washington is here in court with his lawyer, Mr. Melnick, and we've got Mr. Jordan here for the state. And my understanding is that how many was it? 7 felony charges are being condensed into a misdemeanor.
Yes.
And I'll let you explain the structure of that. But Mr. Washington, for your purposes, in just a moment, Mr. Jordan's going to put you under oath, ask you the kinds of questions you just sat through, but they'll be tailored to you and your case. You'll need to give truthful answers, and you'll need to let Mr. Melnick or me know if you've got questions of your own, okay?
Yes, sir.
Great, when you're ready.
Thank you, Your Honor. And Your Honor, before I swear Mr. Washington in, the state is moving to dismiss counts 1 through 6, and I'll provide the reasoning as I give the factual basis. As to count 7, the state is moving to reduce that count to a violation of a family violence order. That is OCGA 16-5-95.
Okay, which is a misdemeanor, as far as you know.
That's correct.
Okay.
Mr. Washington, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you very much. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Adrian James Washington Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
52.
What is the highest level of education that you've completed?
Graduated in some technical college.
When you say graduated, do you mean graduated high school?
Graduated high school.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with 1 count of violating a family violence protection order?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Mr. Melnick, about all of the facts and circumstances known to you regarding the remaining charge in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Melnick, are you satisfied that your client has a full understanding of this proceeding?
Yes, sir.
Mr. Washington, do you recall originally having been arrested on the charges of burglary and aggravated stalking?
Yeah. Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Mr. Melnick, do you know of any outstanding warrants that are related to the remaining charge?
No.
Mr. Washington, do you understand that you are entering a plea of guilty to 1 count of violating a family violence protection order?
Yes, sir.
Do you understand that the minimum for that particular charge is 1 day and in custody, and the maximum is 12 months in custody?
Yes, sir.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as to counts 1 through 6, the state is moving to dismiss those counts. As to count 7, the violating family violence protection order, the state's recommendation is 12 months probation, and that Mr. Washington have no contact with Ms. Samantha Washington.
All right.
Mr. Washington, is that the negotiated recommendation that was communicated to you?
Yes, sir.
Do you understand that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on this charge?
Yes, sir.
Mr. Washington, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Do you understand, my apologies, are you currently on probation or parole?
No, sir.
Are you a United States citizen?
Yes, sir.
And Mr. Melnick, is Mr. Washington going to use his first offender on this?
So I have not actually really discussed it with him, being a misdemeanor. I mean, I think he does have a couple of prior misdemeanors on his record, if I remember correctly. He doesn't have any prior felonies.
No felonies.
So you can enter this plea under first offender, which means that it wouldn't be a conviction on your record. Very often I would tell somebody not to use that on a misdemeanor. Quite honestly, you're 52 years old. It's pretty unlikely you're ever going to be charged with a felony, right? So
Right.
as long as you don't think you're ever going to be charged with a felony, this would keep it off your record.
I
You
would
want to do that? Yeah. He would like to avail himself of Title 42 first offender in this case.
He would.
Yes.
Okay, we'll cover that.
Mr. Washington, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir, I am.
Have you ever pled guilty or nolo contendere or ever been convicted of a felony in the state of Georgia or any jurisdiction?
No, sir, I haven't.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No, sir, I haven't.
And from your lawyer explaining the First Offender Act to you, do you feel sufficiently that you understand what the First Offender Act is?
Yes, sir, I do.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this indictment?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you were in fact guilty?
Yes, sir.
Mr. Washington, how do you plead to one charge of violating a family violence protection order and indictment number 23 SC 186964?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that since this is a misdemeanor that you're entering a plea to, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Your Honor, for a factual basis, essentially the timeline is important in this case, Your Honor. On August 29th of 2019.
2019.
Yes, Your Honor.
Okay.
Ms. Samantha Washington did call the Roswell police to report domestic violence. She did state that Mr. Washington had choked her by applying pressure to her neck, specifically putting his thumb on her neck, causing her to lose the ability to breathe. At that particular time, the officers did not take out warrants at that moment, but they did tell Ms. Washington to take out a temporary protective order, which she did on August 30th of 2019. That's where some of the issues come in, Your Honor, in regards to the first 6 counts. The protective order that we have is 2019 CV 326006, as listed in the indictment. Your Honor, there was some confusion about whether DeKalb ever served Mr. Washington with that particular order. The initial notes that when the case was indicted indicated that Mr. Washington was served with that order on August 30th of 2019. The state had no documentation to prove that. The documentation that the state actually had says that Mr. Washington was served on September 4th of 2019 when he was in custody of the Fulton County Jail. So there was an incident on September 2nd of 2019 where Mr. Washington was at 5109 Creek Parkway in Roswell, Georgia. Ms. Washington took the children that they shared together back to the apartment and was surprised to see Mr. Washington there. That's when he was arrested for the first 6 counts of this indictment, burglary, and the first 5 counts of aggravated stalking, which deal with Ms. Washington and the children. Your Honor, after September 4th, there was a hearing on September 20th of 2019 in which Mr. Washington was present. When that particular order was discussed in open court, it did give Ms. Washington possession of the 5109 Calibri Parkway address. And it also made it very clear that there was a stay away order that was in place.
Got it. And that's why count 7 survives, because that's from between October of 2019 and January of 2020. Mr. Washington is allegedly still contacting Samantha Washington.
That's correct, Your
Okay.
Honor. So that's why the state moved down to only the 7th count. The particular emails, and Attorney Melnick and I have discussed this since Mr. Melnick got the case. The emails themselves are pleas from Mr. Washington to rehabilitate their marriage, to get counseling, to continue going to church together. I think the disagreement that we just had was that, as particular as it says in the aggravated stalking statute language, the harassing and intimidating nature of the messages. On their face, the emails were not of harassing and intimidating nature. It was just, if the case had proceeded forward to the bench trial, I believe because of the past instances of domestic violence that took place, that any communication, especially after Mr. Washington had been served twice in the Fulton County Jail and also had the hearing on September 20th of 2019, would have been harassing to Ms. Washington. So in regards to the reduction, the state spoke with Ms. Washington on Friday, as indicated by the email sent to the court. She was fine with the misdemeanor reduction. She just wants her goal from indictment has just been that she does not want contact with Mr. Washington. She wants to completely move on with her life. She does not want anything to do with him. So
how does that work with the kids? Or are they not his biological kids?
from my understanding, there is at least one biological child that they share together, and Mr. Melnick may be able to shed light upon that, but she does not want him reaching out to her at all.
Okay.
Your Honor.
All right.
And Your Honor, Ms. Clark does have a victim impact statement from Ms. Samantha Washington to read into the record.
Great. I think now is the time. All right, Ms. Clark.
Good morning, Judge.
Good morning.
Can you hear me? Okay.
Yes, ma'am. Can you hear us?
Yes.
Okay.
I will be reading a victim statement from Samantha, common spelling Tompkins, THOPMKINS. The statement reads, I was so proud to be pregnant by my husband, Adrian. I cannot wait to call him and tell him. He and his cousins started to celebrate at our house, and then the stress of him talking to other women continued to hurt our chances of keeping our child. And then while on bed rest from coming from the hospital, still trying to hold on to our baby, Adrian got a phone call. I was so not stressed until a woman on the other end said, "Good morning, baby." Then even said and continued to threaten that I have a miscarriage. I told Adrian she called. When he left me his phone to use. He strangled me when I started asking about the woman, and I began to bleed and have pain that was so excruciating. I bled on my bathroom floor with my 17-year-old daughter to help me clean up and not really knowing what was going on. The only thing I could do was cry as Adrian was on the balcony having a cookout. About 3 weeks later, I was able to get a restraining order against him after going to the military for help in my school. I want nothing to do with him. This woman being with him is my blessing to keep him distracted from me, and I hope she knows that I appreciate that. He has made several attempts to contact me and to get me to believe as to why we are in court today. I thought that he was trying to apologize for what he did, but he only wanted to verbally abuse me. Please, Your Honor, I know you can't do anything about that day and it's gone, but I need this man to stay away from me and my children.
Thank you, Ms. Clark. I appreciate you sharing that insight. So I guess it's Ms. Tompkins now?
Yes, Judge.
Okay, got it.
And Your Honor, I apologize. I did neglect to mention that that was one of Ms. Tompkins' concerns as well, is that the initial strangulation she did say to me caused a miscarriage. But We do believe that this is a fair negotiated resolution, given Ms. Tompkins' desires to, one, not come into court and testify and have to see Mr. Washington again, but just that the particular emails that we were left with were of a nature to where just on their face, they were attempts to rehabilitate the marriage. But we do believe that this end goal is just, this is what Ms. Tompkins wanted from the beginning.
Got it. Okay. Ms. Hardy, what do you have for criminal history information for Mr. Washington?
This defendant has 19 arrest cycles in Georgia, no felony convictions. The last arrest was out of Roswell in September of 2019 for aggravated assault. It got dismissed. And then there was 3 probation violations. Nothing further to report.
Thank you. Mr. Melnick?
Judge, I think Mr. Jordan has done a pretty thorough job of explaining exactly what the situation here is. So I have never actually seen a return of service as far as Mr. Washington actually having been served with this restraining order. But I do think that there's at least a arguable factual basis for count 7 as amended, because he was aware of the restraining order and he did send a couple of emails. The emails were not of a harassing or intimidating nature. They were really, he was asking her to come to marriage counseling with him. He was saying, I want to make this marriage work out, that kind of thing.
Sure. But we're inconsistent with a TPO of which he had notice because of, at a minimum, the hearing on September 20th.
So in all honesty, I was just asking, he actually was not present for the hearing on September the 20th.
Okay.
But I think that when they arrested him initially, they told him that there was a restraining order.
Okay.
So he had, at least, like I said, an arguable knowledge basis to know not to contact her. So I did, briefly discuss first offender with him. He is eligible for first offender. I know he has a couple of prior misdemeanors, but I think it was all driving related offenses, like driving on suspended license and that kind of thing. So he is eligible for first offender, and he would like to avail himself of that on this charge.
How's it going to work with kids or child if they have children together? He, Mr. Washington, for the next 12 months cannot contact Ms. Tompkins for any reason.
Sure. I asked him about that. He said there hasn't been any provision for visitation up to this point.
Okay.
So it's just something that they'll have to figure out on their own once this probation is over.
Okay. Mr. Washington, how many kids do you have with Ms. Tompkins?
Actually, Your Honor, 0.
0. Okay. So she has kids and you were a stepfather for them?
Yes, sir.
Got it. All right. So they may want to see you and you may want to see them, but it's not one where you've got a biological right to see them.
Yes, right, Your Honor.
Got it. Okay. Are they old enough that they're reaching out to you?
At least 3 of them are.
Okay. You'll just want to be real careful with that. Nothing I'm saying is about your relationship with those kids, but you shouldn't use them as a conduit to Ms. Tompkins.
I understand.
And she may view that you are, even if you're not. I mean, you may say, hey, guys, what's going on in the house? Oh, everyone's good. Mom is too. You didn't solicit that. You didn't ask them to do that. But don't write back to them saying, tell your mom I say hi. Because that's indirect contact. You are, through your stepkid or former stepkid, trying to get something to Ms. Tompkins. So you're just going to have to be delicate there.
Yes.
I'm not saying you can't see those kids. And if one of them is 18, that person makes his own decisions. If they're younger, it's just a little more complicated because it sounds like Ms. Tompkins is their guardian.
Yes, sir.
Do you have kids of your own?
Yes, sir.
How many?
2.
Okay. And do they live with you?
My oldest do. My youngest stay in Tallahassee.
Okay. But you've got one with you.
Yes.
How old?
18.
Okay. All right. Do you have any questions about anything we discussed?
No, sir.
All right. Well, Mr. Washington, I find there's a factual basis for a plea to the misdemeanor, it's a new one for me, of violating a family violence order. I think that fits these facts. I think a jury could find that you knew there was some kind of TPO out there. And while it was innocent enough, saying, hey, could we get back together? This statute says nonviolent contact falls under this. Aggravated stalking suggests, you were banging on her door and let me in. That's not this case, hence this plea. First offender, you are eligible for first offender. I just want to make sure you want to use it up because you get one. If you're pretty sure that you're not going to get mixed up in anything in your remaining 50 years or however long you're going to live, then this can make sense because it's not on your record. While you'll be on probation, it's not a misdemeanor conviction. And when you're done with your probation, it comes off your record and you can get it expunged, et cetera. But you're using your first offender on a misdemeanor, which may be, given the life you've led, a perfect use for it. When I'm dealing with younger guys who are, I'm not so sure, I'm not done running in the streets, you really want to burn it right now because something could happen in 6 months where you get arrested for burglary. I know that's not you, but I just want to make sure you understand that you're using it up. You don't get to bug Mr. Melnick next time around. It's like, hey, I want to use that second offender. There isn't such a thing.
I understand, yeah.
Okay.
I'm not a troublemaker. So.
I don't have that sense at all. I just need to have that conversation with you because it is not common that people use first offender on misdemeanors in my realm, but that's because I'm dealing with folks who are getting felonies and they want to use it there. But my hope for you is that you're done with the judicial system, the criminal justice system after you're done with this case.
Yes, sir.
All right. Well, I find there's a factual basis and that your plea is knowing and voluntary. I will sentence you as a first offender. Mr. Melnick, can we sign the indictment for you?
Yes, Judge.
And Mr. Jordan?
Yes, sir.
Mr. Washington, is it okay if we electronically put your signature on indicating your plea to one misdemeanor as a replacement for count 7?
Yes, sir.
All right, we'll do that. And your sentence will be 12 months probation. The only special condition is no contact at all, direct or indirect, with Samantha Tompkins, also known as Samantha Washington. Anything else, Mr. Jordan?
No.
Okay, Mr. Melnick? Mr. Washington, I'm going to need you to stay here. Misdemeanor probation is going to come by and get you signed up. So they'll let you know when you need to have your first session with them, or maybe it'll only be telephonic, whatever that is. But if you'd stay here,
Yes,
Deputy Gordon's going to keep the courtroom open and they'll come by here and get you signed up.
Yes, sir.
Okay. Before folks go, there was a little chatter here. Oh, no, we're good. Okay. Excellent. It was a question about you, and then she realized it's misdemeanor probation, not her role. Okay. Thank you, everyone.
Thank you.
Thank you.
Thank you, Young.
Thank you, Ms. Rivers.
Okay, Judge, thank you.
All right. Ms. Hardy, thanks for your help.